Hi, good afternoon and welcome back to our first construction clinic in July. It's been a couple of weeks since we held one of these. We're delighted to welcome back Andy Hewitt and Mark Watson of the ICCP. Before we get started, just a reminder that your microphones are in mute mode. And of course, today's clinic is all about questions. So if you do have any questions for our panelists today, you should find a question box on your control panel and feel free to send them in to me and I will field them across. Before we get started, we just have a short introductory presentation to the ICCP. There are some names who we've not seen on the clinics before, so welcome if you are new to the sessions today. And we just want to go over a few bits of key information to tell you a bit more about us. So what is the ICCP? Well, we are a professional members organisation and we recognise those with skills, qualifications and expertise in the professional management of construction claims. We have three primary objectives, and those are to establish international professional standards for the management of claims, to give recognition to those who have gained appropriate knowledge and experience in the management of claims, and also to help and educate those who would like to gain this experience. So membership, we have three levels of membership: associate, member and fellow. I'm not going to go into the details of all the requirements for each today, but safe to say that each level comes with a defined set of criteria which must be met to join at the desired level, and that criteria gets more stringent depending on the level that you're applying for. So for example, at associate, we're opening the doors to those perhaps more junior in their career that would like to gain knowledge and experience and grow to full member. And then at the other end of the spectrum, we have fellow, who would be what we would class as experts in their field, and entry at that level would require a significant level of qualifications and expertise. I'd also just like to mention that we do offer concessionary fees, so depending on where you reside in the world, you may benefit from a 50% concessionary rate across all fees. So if any of that sounds interesting to you, check out the details on the ICCP website. You'll also find a list of countries where the concessionary fees apply, and the details are on your screens there. So our website link and also my contact details. If you have any questions, I'd be happy to have a chat and send you some more information. Okay, so on to today's clinic. As I mentioned, we welcome back Andy Hewitt and Mark Watson. Andy is FIDIC contract and claims expert. He's also the author of a couple of books, Construction Claims and Responses and the FIDIC Contracts Obligations of the Parties, which you may be familiar with. And Andy is our Executive Officer and Fellow of the ICCP. Then we have Mark. Mark is a self-employed construction claims practitioner. He's also experienced in delay analysis, expert witness, and mediator. In addition to Mark's many professional memberships, he's also an ICCP fellow and sits on the ICCP steering committee. So over to questions, and I believe Andy's going to kick things off for us today.
Yes, thank you, Nina, and welcome to everybody. Thanks for signing in and joining us. The panelists do enjoy these clinics, and I hope that, sincerely hope that you get some good information out of them. And really, you know, we do this from altruistic point of view, but we also like to encourage potential members to have a think about joining the ICCP. We're a small, very friendly organisation. You'll get to deal with people who are real faces, such as Nina and myself and the committee. It's not one of these faceless organisations, and I won't quote any, where, you know, you just feel as though you're dealing with a load of administrators and it's very difficult to get assistance and help when you want it. We have a very personal approach to our members, and we try to help them as individuals. Anyway, on to the first question, which was submitted by Junaid Limbada, who I actually know because he's one of our students on our claims class courses. He undertook the distance learning course on construction claims. And in some respects, Junaid, I'm going to have to slap your wrist a little bit, because I thought you'd learnt on the course to be a little bit more specific when you're writing things. So my answers to the questions are going to have to be qualified, but Junaid's asking for some guidance on the FIDIC consultancy contract, which is the white book, in terms of management of a consultant on his project. And the first part of the question, excuse me, is what cost is allowable and what is not. Now, I don't know the nature of the consultancy. Is it a designer who works on a lump sum price plus variations? Is it a cost consultant who's maybe employed for the life of the project? Is it a site supervision is it the engineer? I really don't know. Or what costs that he's trying to claim, or you're thinking about paying him. I've had a quick look at the white book, which is not one of the contracts that I deal with on a regular basis, but had a quick look in there, and there's absolutely no definition of cost in the white book. So if it concerns a variation to the consultant services, so redesigning something, designing variations, possibly being deployed on an extended period because the contractor didn't finish on time, we've got to look at the nature of what he's claiming additional payment for. And should that be cost as defined in FIDIC, i.e. cost actually incurred, or should it be something that we should be fairly paying him his overheads and profit on, or at least profit on? Has he been prevented from deploying his staff onto another project? And has he lost profit on that other one? So there are lots of things to consider here. Sorry, I've made a few other notes. Okay, next part of the question is, can I refer to the delay and disruption protocol as the contract requires the consultant to abide by international practices and standards? Well, I think Junaid here is referring to the Society of Construction Law Delay and Disruption Protocol. Possibly you can refer to it for some principles, but you know, the protocol is designed to give guidance on contractors' matters, so extensions of time, the cost that contractors can claim. It's not really designed for use in consultancy agreements. Please advise on the entitlement due to the consultant in terms of cost. Well, again, the consultancy agreement doesn't refer to cost, so that's not a basis. If he's a designer and had to do some extra work, that will be a variation to his services. And if you've set the consultancy agreement up correctly, and this is where the white book leaves an awful lot to the discretion of the person or people who are creating the contract and drafting the contract, there should be a mechanism within that contract to evaluate for additional work. So whether it's additional services, we had to redesign part of the job because the employer wanted it changing, or whether it's time-related services, such as the engineer on the project that was originally employed for 24 months, but the project's been delayed for 6 months, so he needs to deploy his staff for additional 6 months. So, you know, what staff's been deployed during the period of delay? Have we got, presumably we've got an agreed monthly rate. So very difficult to answer the question, but I hope I'm giving you some principles to think about. It possibly is, the question that Junaid's answering is because he's saying, will the time impact of an extension to the completion date of the project be necessary to demonstrate at this stage of the claim? Now, I presume here we're not talking about an extension to the consultant's lump sum services because he was delayed finalizing the design, because maybe a schematic design, the employer wanted a load of things changing, so we had to redo a lot of the design that he'd already had, which took the consultant a longer period to finalize the design. Or if we're talking about time-related services, such as maybe a cost consultant or the engineer or the site supervision contract, well, yes, that would be related to the contractor's extension of time. So if a 24-month contract, the contractor is delayed by 6 months, the engineer needs to be deployed for an additional 6 months to administer the contract. Well, I guess it's not a case of what extension of time is the contractor entitled to. If he was delayed by 6 months, maybe he's only entitled to 3 months extension of time, and it was a 3-month delay by the contractor. But your engineer, your cost consultant, your site supervision consultant, unless the employer wants him to go away after 3 months, has got to be there for the full duration of when the contractor is on site. So again, difficult to answer, but I hope I've given you, Junaid, some things to think about when you are trying to pay or evaluate additional payment for your consultant on your project. So I hope that helps. Sorry, and that would be my questions over. So over to Mark for some discussions on programming, delays and force majeure on a JCT contract.
Thank you, Andy, and good afternoon, everyone. I'll be responding to 3 questions submitted by Danielle Pine. Turning to the first question, Danielle asks, relating to the program under a JCT contract, please advise reasons on why employers may in some cases do not want to include a program as a contract document, and what are the potential implications which may arise. Now, this is a very recent Danielle. Most construction contracts require the contractor to produce a program of its works, and normally expresses the set form the construction program must take. The 2016 edition of the JCT contract requires the contractor to provide the architect or contract administrator with a copy of its master program for the execution of the works, identifying the critical parts. However, the critical parts only be identified should the contract particulars require this to be shown. The master program is not, however, included in the list of contract documents under the JCT contracts. So in the circumstances where the program of works is included in the list of contract documents, it would mean that program will become binding on the parties. And as with everything else in life, there are advantages and disadvantages associated with doing that. So let's look at the advantages first. The advantage for the employer is that it will afford him greater control over the manner and order in which the contractor will carry out the works. In other words, it will allow him to specify the works that are a priority, and will thereby oblige the contractor to prioritize his works in the same manner. The advantage for the contractor is that he will be aware of what is expected of him from the outset. The same applies to third parties such as suppliers and consultants. In my experience, I've often found that the consult suppliers are often ignorant or left in limbo as to the timing of their own contributions to the works. And therefore, in this instance, if the program is made a part of the contract documents, it creates a better exposure and visibility to what the requirements are to third parties. Now, turn to the disadvantages. The disadvantage of including a program in the list of contract documents mean that the contractor and employer will assume additional responsibilities, and it may lead to additional claims over the contract. So if you look at the employer will have to provide the contractor with the facilities to complete the works in accordance with the program. So that means that he's going to provide his drawings, he's going to provide access and his drawings, and anything else is required to provide under the contract at those dates specified in the program that forms part of the contract. And should the employer fail to facilitate the progress of the works as stated in the program, the contractor will be entitled to compensation in the resulting lost time and money, subject to the requirements of the actual contract. If the contractor is bound by the program, it may considerably reduce the flexibility of his site operations and may expose him to risks to additional claims for breach of contract. As I said earlier on, that he'll be obliged to work according to the program that forms part of the contract. So he has got less control over his program and his flexibility to move his people around as he wishes, because those works that are set as priority by the employer, he needs to focus on those works first. So given the advantages and disadvantages, I would advise the parties to seriously or to apply their minds when trying to consider or when considering if the program should become part of the contract documentation. Keeping in mind as well that by the time the contract is entered into, you're only working off tender documentation. So the program in your tender documentation might not be as advanced or as detailed as what you would like it to be. And that's another consideration when deciding on whether the program should form part of the contract documentations or not. Turning to the second question, relating to matters of concurrent delay, Daniel asks, concurrent delays under JCT contract. In a hypothetical scenario, the employer is responsible for causing a delay, for example, failing to issue design information on time, which led to an initial 4 weeks critical delay to the concrete frameworks package. As the project progresses, it is apparent that the contractor's weekly output of concrete against the contract program has continually been in deficit, and duration to complete all elements have taken longer than stated in the program, which caused a further 3 weeks delay on the planned completion date, or 3 delays to the planned completion date. Is the employer entitled to apportion the delays and grant the contractor an extension of time, net entitlement of 1 week, or will it be 4 weeks EOT because the first critical delay was caused by the employer? What happens if the first delay was caused by the contractor? So now the 2016 edition of the JCT contract is silent on the treatment of concurrent delay. However, on reading your hypothetical scenario, this does not seem to relate to a concurrent delay, but rather to a sequential delay. And the reason I'm saying that is that your first event is right at the beginning, relates to delay in issuing design work, and your subsequent events relate to rate of progress. Normally, your design work will first have to be finalized before you can start working. So therefore, your design work may not necessarily be concurrent to your operation work. And if I understand correctly, was a number of the rate of progress and a continuous effect on the works. So therefore, concurrent delay, it all depends on the definition under the various jurisdiction. And jurisdiction means the various law of other countries. So the treatment concurrently under Scotland is different from the treatment concurrently under England. Scotland will work as made rewards on case law on apportionment method. England has rejected the apportionment method. In South Africa, our current law states that you can get time and cost regardless of whether you are in delay or not. So let's turn to your first event. The first event complained of relating to the delay in issuing the design drawings. Now, in that instance, so when you update your program, analyze the program, your first event will then move out your completion date. Now, if you want to move your or revise your planned completion date, your planned completion under contract means the date at which you're contractually bound to complete the actual works. Now, and also the design delay is regarded as a relevant event under the JCT, and for that reason, you can apply for extension of time subject to meeting the procedural and substantive requirements relating thereto. So let's, for argument's sake, state that you are awarded extension of time. Now the completion date will move out by 4 weeks, just for ease of reference. That becomes your new or your prevailing completion date under the contract. So now your work stopped and your progress issue becomes a problem, and now it moves the date at which you plan to complete the works at the date later to the completion date. That means that your current rate of progress will delay the works for the date at which your program shows you plan to complete the works. If that continues for a period of time, then that date at which you plan to complete the work will shift out and shift out and shift out. So let's, for argument's sake, rate of progress, your rate of progress, the work's completed at 6 weeks later after than the completion date of as advised in the contract, or the prevailing completion date. That 6 weeks period would then become the period for which you are inculpable of delay, because a contractor's rate of progress is not regarded as a relevant event under the JCT. Therefore, during that 6 weeks period, the employer can impose liquidated damages to you. Okay? So in your second scenario, where you ask what happens if the first delay event was the contractor's delay event. In the circumstances that the first delay event was the contractor's event that delays completion of the work, and the employee's delay event occurred sequentially thereafter, then the contractor may not have a remedy. And I refer you to clause 2.2861 of the 2016 edition of the JCT Standard Form Contract, which provides that the contractor shall constantly use his best endeavors to prevent delay in the progress of the works or any section, however caused, and to prevent the completion of the works or section being delayed or further delayed beyond the relevant completion date. So if your first delay, if the first delay in the works is attributed to the contractor, the contractor has offended this clause, and he may not be entitled to get extension of time applied in remedy in the contract. It's also, you've got to consider what any amendments were made to the contract, and also sometimes contracts have exclusion clause, especially when it comes from current delay. So those are all matters you need to consider. But my understanding of this event is that in the event that the first event delaying completion or moving out the date for completion is a contractor's event, then you might not have a remedy on the subsequent events thereafter. And turning to the final question, relating to force majeure COVID-19 under JCT contract. A concrete contractor had supplied and erected a tower crane as part of the scope and finished their contract works pre-COVID. On completion and handover of the works to the employer, the extended hire period starts purely for employer use only and is valued on a provisional quantity basis, say 40 weeks hire, subject to remeasure. Force majeure is the main reason why the employer needed to extend the hire period to mitigate delays and disruption of follow-on trades. The additional hire charges incurred beyond 40 weeks should be an employee's risk event. Therefore, the contractor is entitled to additional money, variation to 10 weeks, if the actual hire period was a total of 50 weeks. Do you share the same view? In this situation, the force majeure COVID-19 and loss of expense claim is not relevant here and is not a reason for not paying the additional hire charge due to the contract. So now, my response is this, that you cannot say that the loss of expense claim is not relevant, because you need to refer to the contract. Your contract supersedes all those conditions or those issues that you deem to be relevant or not relevant. So it needs to depend upon whether there was agreement in place and the conditions of our contract relating to the extended hire period. Now, let's for argument's sake say in the circumstances that the agreement for the extended hire period was in place, but the agreement does not contain a force majeure clause, or the force majeure clause does not name the unforeseen event that the employer wishes to rely on. Then the force majeure clause in that instance, in that circumstances, cannot be relied upon. Okay? However, I have a current client, and we're sitting with exactly the same situation, and what we have done, but this is only relevant to common law jurisdictions. What we have done is we've relied on the common law principle of supervening impossibility of performance to suspend our client's obligations under the agreement. However, this is subject that we can prove that it becomes impossible for the employer to perform under the agreement as a result of an unforeseeable and unavoidable event. In these circumstances, we may not have an obligation to pay an additional 10 weeks, or the client would not have an obligation to pay the additional 10 weeks. However, please be advised that this remedy sits under common law jurisdictions only and will not be advanced as an argument under civil law or other jurisdictions. In addition, I would advise you to take legal advice in this matter. That's all questions today. Back to you, Nina.
Thanks, Mark. We have a few minutes left, and we actually have a follow-up question in from Junaid, which Andy's going to answer.
Yeah, sorry, I'm just trying to actually find the question. Just a minute. Nina showed me how to do it once, but I can't actually find it again. Let me start from the beginning. Just while I'm just an observation I have on the last question that Mark answered. The guy with the tower crane, it's a bit like, you know, you've leased a car from a car hire company, and you've taken out an agreement to lease it for 2 years, and you say to the leasing company, oh, it's COVID, I'm in lockdown, I'm not using the car, I don't want to pay the lease. It's a very similar scenario, and I don't think anybody will say, oh, yeah, it's okay, I know you're not using the car, don't pay us the monthly lease fees. So some people just try it on. And I'm still trying to get this question from Junaid.
If you look on the control panel, Andy, about halfway down in the dark grey banners, you'll see the question box.
Yeah, I got that.
And then on the right-hand side, there's a white square with an arrow pointing up and left. If you click on that, that will pop it out of the control panel, and the question should pop up on your screen there.
Yeah, I've got the question, and I've got Junaid, but I can't actually read the question. All I can get is the consultant is not doing the contractor's construction scope. So I'm only getting half of the question, but I think I can remember it. I think Junaid was asking that because of COVID, the consultant wasn't able to perform any services, so should he be paid extra? Again, Junaid, I've got to go back. Is he a design consultant that was supposed to be providing a set scope of works, and did COVID delay him from doing that? Or is he a site supervision or engineer consultant where his scope of services is related to the time that the contractor is on site, and the project was in lockdown, so the contractor wasn't working for X number of weeks? So in this case, it's not a variation, but I think you've got to go back to the white book and have a look at what force majeure says. If we can qualify COVID as being force majeure, and I think most considered opinions agree that COVID can be considered as force majeure. What does the consultancy agreement say about force majeure? Whose risk is it? Will the employer pay the consultant if it's suffered through force majeure, or is it something that the consultant's got to suck up, and there's no avenue for him to claim through the contract? So again, probably not answering or giving you an answer that you want to hear, but my advice there is to look in the white book to see what it says about force majeure and who carries the risk. So I hope that helps, and sorry for not being able to find your question. So that's it from me. Well, I think we'll be back. Nina, are you going to do a closeout?
Yes, that's it for today. Thank you for everybody's questions. Just a reminder, the clinics are taking place every 2 weeks now instead of weekly. So the next one will be on the 28th. Look out for the registration links in the invitations and on our social media pages. And the the registration link will normally go out in the invitation. It won't this week. So if you're used to seeing it there, it won't be there. We're removing webinar software at the moment. So the fingers crossed, if we can get our heads around the new software, that will be done using the new software on the 28th. So do make sure you're on our mailing list because invitations will go out. If you have any follow-up questions for today or any questions about the ICCP and membership, do get in touch with me. I did actually have a question about past construction clinics today. All of the previous sessions, there's 14 of these now, are up on our YouTube channel, and we've created a playlist specifically for the construction clinic. So check that out. The link's on the homepage on our website. There's about 22 webinars up on there in total now between the clinics and the series of public webinars that we did last year. So lots and lots of good technical content for you to wade through when you've got some time. Right, thank you to everybody, and we'll see you again in a couple of weeks.
Okay, thank you. Bye-bye. Thank you, Nina.
Thank you. Bye-bye. Thanks, Annie. Thanks, Nina.